Yes, Janelle Renee Manigault.
Thank you. Your Honor, I believe Ms. Manigault the test was overbooked and she was told that she has to reschedule.
This is never gonna end. So when do you have it scheduled now, Ms. Manigault?
I have to call again, sir. I have a toothache. I'm sorry.
What's my date in July? Get it set, please.
Yes, sir.
I'll just adjourn this out to July 19th,
Thank you so much, Your Honor.
2023, 9 a.m.
Court, for the record, I'm attorney James L. Galen Jr., P43406. Your Honor, I do not believe my client is on Zoom. I did reach out to her by texting her as well as calling her phone this morning. I did talk to her 2 days ago. I did call her mother this morning. Her mother said she's at work and she's trying to contact her. Can we pass on this matter?
Not really. Is she coming into the Zoom here?
I expect she will, Your Honor. She's never missed. I did talk to her 2 days ago. I've got no explanation as to why she's not already here.
She's got till the end of the block to show up, otherwise.
Wow. Just listening to the judge threaten a bench warrant if the defendant doesn't show up really sets the stage. You can feel the tension in the courtroom. Every second counts, and the stakes are high. Imagine being on the other side of that call, not knowing if you're about to face a warrant.
Mr. Martin is a gun collector and has a large collection of guns, and he holds a valid concealed pistols license. He was requesting that the court modify his pretrial release order to remove that provision, given the fact that this is a failure to secure a load. He has no prior criminal history. It's not a violent offense. He's been compliant with everything else that the court has ordered. He just does not want to have to, if the court is willing to agree, remove all of his gun collection from his home.
Response from the people.
Your Honor, I would just leave that in discretion of the court. This has to do with an unsecured load, and so it doesn't really have to do with anything as weapons. But I told Ms. Hammoud that I would not be stipulating to it, and she would have to ask the court.
What I will do is I will delete the provision regarding the possession of weapons. There still be no, as a condition of his bond, he's not to use a weapon.
Thank you, Your Honor.
This is fascinating. The defendant wants to keep his guns despite the legal restrictions. The court has to balance safety with fairness here, and you can feel the delicate dance in every word. It's legal drama and human reality colliding.
Mr. Lambert, can you say your name, please?
William Joseph Lambert, Your Honor.
All right, thank you. All right, what are we doing on these cases?
So, Judge, there's been the family has done a lot of orientation with the Veterans Home in Arizona. There is a bed available for Mr. Lambert. The last thing they are waiting on, and I've already been in communication with the jail medical staff, is a TB test from Mr. Lambert that they need prior to his admission. So they conducted one, I believe it was in late March, and we're working on getting those results sent to me, where I can forward those to this Arizona men's facility, at which point we believe he will be immediately admissible, as all the documentation other than the TB test has gone back and forth by now. So, Judge, the only thing that I would ask, and we do have his bond set up in Judge Valvo's court to allow him immediate release once a bed becomes available, is to make sure that's part and parcel of these matters, so that Mr. Lambert could go to a place with proper memory care, supervision, and the like in Arizona.
All right. So you want me to adjourn this out and adjust his bond to reflect that? Is that?
Yes, please, Your Honor.
All right. Any objection from the people?
None from the township.
my concern, and I did speak to Mr. Siller about this as well, is that last time Mr. Siller and I approved for Mr. Lambert to be released to go to this Arizona facility, he returned to the jail with a PBT result of 0.169, and he returned to the jail at 1:28 a.m. And we were told in a bench conference with the court that he was going to be monitored at all times during this trip. And then he came back with a quite high BAC. So my concern is that if he is to be released, that he would just go straight to this treatment. We would get the proof of that, of him being at the treatment center from someone at the treatment center. And that we would get an update, because I have concerns about the court allowing his release to this treatment when the last time we did, then he came back and he was intoxicated. So that's my main concern.
And
As
Your
is
Honor.
mine.
And Your Honor, I think we've buttoned up the cracks that allowed for that to happen. There was some brief separation on the flight based on seating issues that separated Guardian from Mr. Lambert. I've instructed the family, both guardians, one, that we would be looking at a very narrow window, and that we would propose nothing less, and I'm sure the court would demand nothing less, between the time that Mr. Lambert is released, get on the plane, show up in Arizona. Also, I have the declaration from his guardians that they are not going to allow any sort of separate seating scenario. It was how these tickets were purchased, where the seat was not determined. But this time they understand they're going to be seated immediately next to Mr. Lambert, and to not allow, obviously, neither of them is on board with any violations of bond or alcohol consuming activity. So I think we can button that up sufficiently with orders that would attend to his release. But we have no objection to release with those safeguards in place to ensure that Mr. Lambert isn't drinking during any pendency or any point in time between his release and admission into the Arizona facility.
Here's where the story becomes emotional. Guardians are trying to protect him, but past behavior makes the court cautious. You see the tension between trust, accountability, and human care. It's more than law. It's people's lives.
Is a report. There is almost 2 pages of missed tests or rescheduled tests that were missed. On 5/19, which is the latest notification of the drug testing at 4:10 p.m., the defendant blew up 0.03, and he was required to retest every 15 minutes until he completed a compliant test, and he failed to do so. Yeah.
My main concern, Your Honor, is not the 519. I mean, that is concerning, but on 415, the 0.332 is my main concern. I mean, that's extremely intoxicated. And I did have a long conversation with Mr. Shand about this before I agreed to that 90-day adjournment on the record. If you recall, that I was in favor of it so that he could get some time in. I fully trust Mr. Shand, and I'm sure his client probably told him that he could do it. And while he did do the 90 meetings, to my understanding, this is not acceptable behavior. And regardless if he's doing the meetings and or getting treatment, this kind of violation report, I would be asking for a remand.
Mr. Shand.
Well, Your Honor, on the date in question, the 415, where there was a 332, he did not retest, and they missed 5 or 6 times to retest. However, he tested between 9 and 12 that same day, and there was not a violation. I don't know what happened that day. I've asked my client. He said he did not drink, though that was one of the only 2 times in the 90 days that he actually had any type of alcohol in his breath.
On the 15th, he's saying he did not drink?
He did not. And at the test that he took between 9 and 12 that day, he ended up passing that test because it's not a violation. And I don't know why there would be such an aberration, 0.332. Obviously I've known Frank for a long time, and I know the way he drinks. He's a fifth to a half gallon a day of vodka drinker. So if he was at 0.332, I don't think I would have ever seen him again. But obviously that night he passed between 9 and 12 because there's not a violation. And on the 19th of May, when he did blow, he had very low numbers, 0.03. He had an ETG done the very next morning, and he passed. It was negative. So we have an ETG report from 5:20 at 11 o'clock in the morning, and he was negative.
I don't see, okay, and maybe you're referring to the absence of a test or an absence of a report.
Correct. There was not, if he was testing 3 times a day, if he had missed the 9 to 12 that day, it would have been a violation. He didn't miss, and it's not a violation, which means that he did not blow any numbers. If he blew 0.332 at 2:50 in the afternoon, the 9 to midnight blow, he would have blown some numbers, because there's no way that much alcohol can be out of your system by the 9 o'clock test. It's not a violation. It was not a violation at 9 to 12. The fact that he missed all those retests is concerning, because he should have been testing. And I don't have any excuse for that. However, the fact that he passed the test at 9 to midnight on the same day that he blew 3s in the afternoon doesn't make any sense to me. And as your honor very well know, I was a guy that blew 3s on a regular basis, because you put me in jail because of that a couple of times. So I don't understand why there was such an aberration in the testing, because he should not have been able to pass that evening, and he should have it should be a violation for either not testing or failing between 9 and midnight.
I would tend to agree with Mr. Shand on that, because I mean, I'm concerned on the 19th, is he saying that was also some aberration?
Well, he said he brushed his teeth and used mouthwash. I know. I said that's been heard by Judge Simpson about 73,000 times over the last 25 years. So, however, he did call me about that, and I said, you need to get an ETG done, and he did go the very next morning, an ETG done on the 20th of May, and that was negative.
Okay. So I'm a little bit worried about this report also, because I'm looking at this, and I think Mr. Shand's right. I mean, if you look at just, unless he has some extraordinary elimination rate, that 415 test, well, I'm assuming he took a test later, but I don't see that.
But they're only listing the violations. Therefore, if he took the test later and he violated, it would be a violation. He took the test later and passed.
I've seen it laid out both ways. So, but I get your point. I mean, I've seen it where they then tell me when the next good test is. So at least we have a framework. Here, I'd be making an assumption, but he would have had to test on the 16th, 17th. And I don't see that. Well, what I would do is I would set this for a hearing, because I got to have some understanding of why it's a 3-3. I would agree with you that if there is a past test, that's not going to make sense in terms of just how a human eliminates alcohol. So I will set it for a hearing on the bond violations. When can I do this? 21st? Yeah, but I'm gonna need a special time. I'll set the bond violation hearing for June 21st, 2023 at 3:30. Interim, however, Mr. Mahoney, this is, and it's not, I'm not doing this to punish you for bond violations I haven't found. My problem that I'm having here is you're not testing timely.
Yes, sir.
So, or regularly. Okay, so I'm gonna order in the interim between now and then that the defendant is to report to community corrections for placement on a scram tether.
That would be fine, Your Honor. I think that would be really helpful too, because I sent a long email to Caitlin explaining Frank's retired and his schedule is not a set schedule, and he seems to have problems testing at the right time. And I think a scram tether will be able to give everybody a clear picture of exactly what's going on. And I have no objection to him continuing on tether either, even after we have this case resolved, because I want him to be comfortable. I'm not just his lawyer. I'm his grand sponsor too. His sponsor is a guy that I sponsor. So we talk a lot, and I'm really interested in his continued recovery. He has been doing really well so far.
So what I'm gonna do, you understand that, sir?
Yes, sir.
All right, you need to get yourself over to community corrections today. Get that switched, and then we'll see you on the 21st at 3:30 for the bond violation here.
Yes, sir.
Is that via Zoom, Your Honor, or in person?
That's gonna be in person.
The repeated testing failures and timing issues really show how complicated compliance can be. On paper, it's just numbers, but these numbers represent someone struggling, trying to stay on track. The frustration is palpable, even for the legal professionals.
It's a good thing for me. I'm to thank the court and everybody that helped me out. We got to find a new foundation, get a new lifestyle. I've been clean since December 5th, 2020. So I'm doing good, man. I don't think I'm gonna go back out there. And to help everybody else, I got to give back into this program. It's a simple program. As long as I keep it, don't pick up. Because life is short for a lot of people. And I've been doing this stuff 36 years, and I'm tired, man. And I'm thankful for the help. I'm thankful for Dow's Farm. I got to do what I got to do. It's up to me to do it. Nobody else can change you. Change yourself but yourself. So, thank you, sir.
All right, you just keep it up, because you know how I am. So if you go back to that other way, I'll be out there in the street somewhere. I'll roll up on you. Then I'm just gonna grab you. You know that, right?
Yes, sir.
All right. Yeah, all right, Mr. Malone. You take care of yourself, fella.
Yeah, thank you.
Location 2401 Glencoe Hills Drive.
Here's the human side. Mr. Malone talking about turning his life around after decades of struggle. You can't help but feel inspired. This is why court cases aren't just about rules. They're about people, and sometimes hope wins.
They said that I had blood on me, my feet and my hands was cut up, and they took me to the hospital. They said I was intoxicated, but I was lost.
Okay.
But it's a long story.
All right. So, but you were walking up the street you were in the area of Trinity House. I guess it just says
I
this.
believe they took her there.
When
Yes,
you got to the hospital.
I was basically lost. Yes, I was basically lost.
Okay. But when you got to the hospital, what happened there?
What happened there? I really don't remember that much, but I know that I was lost and they took me to the hospital, and I know they tried to basically sedate me because a man said something probably rude to me, and I said something. Huh?
Okay, but you were out of control. Would that be fair to say?
I was under the influence.
Okay. And you being under the influence kind of made you out of control and you started yelling, right?
That's fine.
That's why
Yes.
they were, that's where they were going to try to sedate you?
Yes.
Okay. And you would agree that your behavior, what disturbed the peace and repose of the area surrounding you? Would you not? Would you agree to that?
Yes. Yes, I would agree.
Okay.
When a defendant explains what happened, you see vulnerability, the confusion, the intoxication, the chaos. It's raw. And the court response balances accountability with empathy. This is real life, messy but honest.
Sylvana Reed, Assistant Public Defender with and on behalf of Miss Sharon Reed, could you please unmute and state your name for the record, ma'am?
Sharon Reed.
Thank you.
You're welcome.
Your Honor, this is a case where we are requesting a supplemental report from the police department. I know that Ms. Kirby has requested it, and we were told it was going to be provided in hopes that we can get this case dismissed. That report still has not been provided, so we could get another adjournment.
Your Honor, I'm sorry, Ms. Reed. So I actually received an email during the docket from the officer. He is actually off on vacation, and he said he was going to send over the supplemental, but he did confirm the property was retrieved. So I am going to move to dismiss at this time.
We have no objection.
You all right with that, Miss Reed? Miss Sharon Reed?
Yes. Yes,
Yeah,
I am.
well, I'm just checking. You don't need to, have it. You don't need to have a grin that big. Case dismissed. All right.
All right. Have a good day.
Take care.
Thank you. You too. Bye-bye.
Court calls again. Did you get yourself married?
Yes.
Okay, so it all happened.
Yeah.
Okay. Well, I worried about it a little bit. I said she's traveling to those disputed territories of Ohio. I didn't know what was going to happen down there, but okay. Well, congratulations, young lady.
Thank
you. All right. Okay, so what we're going to do, just hold on the line. We're going to put you into a breakout room with probation so you can get information and everything. All right?
Thank you.
Thank you.
Have a good day.
You do the same.
Moments like these with adjournments, dismissals, and misunderstandings give relief but also humanize the courtroom. You see the personalities, the patience, the humor, and yes, the occasional frustration. It keeps you hooked.
She looks happy for being married. Anyway, well, I'm sorry. I just thought I'd throw that out there. I didn't know. Court calls again.
On behalf of the people.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Vermeulen. Could you please state your name for the record, sir?
Eric Vermeulen. Eric Vermeulen.
Got it. Okay, what are we doing?
Your Honor, the people move to dismiss this case.
And we have no objection.
I appreciate you. Thank you. Thank you very much. Thank you. I mean, it brings tears to my eyes. It really does. Thank you.
Eric?
Yes, sir. Yes, sir. I was going to plead guilty for you.
Now, you can feel the relief in the courtroom as cases get dismissed or adjourned. But it's not just paperwork. It's lives being affected. You see tension, misunderstanding, and human emotion collide, especially with Mr. Billup's plea confusion. Moments like these remind us how chaotic yet human court proceedings are, and why patience and clarity matter so much.
My understanding yesterday when I talked to him that I wasn't going to get no misdemeanor, it was going to be a fine.
Your Honor, may we have an adjournment? My colleague was the one that spoke on the phone, and I'm just going through the notes in the file, so I'm requesting
Right.
adjournment.
And he had an emergency today. All right. So here's what I'm going to do, Mr. Billups, so you guys can get that straightened out. I'm going to adjourn this out a couple of weeks so you and your attorney can talk, okay?
Sir, I don't have a couple weeks. To be honest with you, I work a lot. I'm at work right now. I just went on break. I had to punch out. But
I can't. Go ahead.
I was supposed to get something like just I wasn't supposed to get no misdemeanor for this.
Okay,
But I
well,
agree, not no misdemeanor, but a fine. I agreed to a fine, a $250 fine.
and that would be typically the fine that I would impose on this charge. But your understanding is you weren't gonna plead to a misdemeanor, right?
Yeah, my understanding, it was just it was supposed to be something about driving, but I don't know nothing about no misdemeanor. I didn't.
Okay, all right, then
He
that's why I'm
told
not,
me-
okay, Mr. Billups, hold on, I don't wanna know, because you and your attorney have your own conversations. All I know right now, and all I need to know is that you thought it was something different than what we're doing. And so
Yeah.
therefore, I'm not gonna take your plea, even if you wanted to give it to me now, because I need you to get that straight with him. So I would adjourn it out 2 weeks, but if you want me to put it out, this case isn't that old. If you want me to, I can put it out to July 5th. If that helps you out in terms of having to take a break and working and everything. I mean, but that's the best I can do for you. 2 weeks
Yeah.
or 4?
4 weeks.
4 weeks would be better. Okay, then I'll do that for you. July 5th, 2023, 9 a.m. And that way you can talk with your attorney and everything and get it all straight as to what's happening, okay?
Okay.
Here's where the courtroom drama peaks. Mr. Billups clearly misunderstood his plea, and you can feel the tension build. The judge carefully navigates between fairness and procedure, giving him time to sort things out. It's a perfect example of how legal processes are not just rules on paper. They're human, messy, and full of moments that keep you on edge.
Fines and costs of $250. I'll suspend 90 days in jail. When can you get that paid, Bam?
I would say, can we do like 2 months?
2 months.
Look,
Well,
I
yeah,
can
no,
do-
I heard the 2 months. She wasn't quiet about that. She said 2 months. Came out kind of loud. She like, you know what? She like Clay up there. He said, everybody trying to give me a hard time today. You really need 2 months to pay this?
All right, you can do a month. I just moved into my place.
You know, did you see that?
You know, I had to,
See, you really need 2 months. Well, you can go a month. How about that?
a month is fine. Yes, that's fine. I'll have to
Just
settle.
listen. Just stop. Just stop. Here's what I'm gonna do. I'm gonna quit asking you. Just pay it July 31st. So
Okay.
it's a little under 2 months.
Yeah,
All right.
that works for me.
Yeah, all right. But if you don't get it paid, we won't come find you. All right.
I don't need that happening. Okay.
Okay. All right. Take care, man.
Bye.
Thank you, guys.
It's like
Everybody
the-
have a great evening.
There's a reunion here with Ron today. Reunion.
I know. This is like it's like going to the old folks home. I don't know what that's like.
Oh wow.
Anyway, no. Always a pleasure, Mr. Brown.
Always a pleasure. Good to see y'all.
Yep, good seeing you.
All right.
Take
Take
care.
care.
All right.
Bye-bye.
14A stands adjourned. Thank you, Ellen.
Hey, Elin.
Thanks a lot, Judge.
Did it?
You guys have a
Alrighty.
good one.
Bye.
Finally, closure. Fines settled, cases resolved, and people getting a second chance. These are the moments that remind us that law isn't just about punishment. It's about justice, fairness, and yes, sometimes redemption. And hey, don't forget to subscribe. These stories deserve to be seen.